Eti for akwa baba tele update TV na message send aba channel issue and wa hit do man no subscribe no like no shama when a pen send me bi etie so ene bi etie na jebre ye mu nwanse ne den semi twagu ye famu nsemu nyina mrebo na je say the controversy aspake e fa tokono issues ne ho ni nyina the petitioner say o mahama say by force na onyi chief justice said ni nyina the misconduct ne niema esisisichia Afenyo market so ni ahụ no don pre do mu beji ma ema even though mo bekaya lawyer Tamakuru site example bi a wode Sophia Akufo empo ne pension no Charlotte say ebisi ma emu nsem no na me pese this time no em say enkomo no aye de pay yam pese ye gibre ni eboram na yetie some of the controversy na espake for tokonoshi mover no yeba de akabia no yeso yede emu ensem ina bebrem.
The request sealed the petition before giving it to her. Who informed the minority of the details? If her ladyship, the Chief Justice, in communication with the minority, because at this point, the petition is between the President and the Chief Justice. And in fact, for the President to guide the integrity of the process, he sealed, he marked the petition. I've heard one other journalist of Metro refer to what they claim to be the content of the petition. Who leaked to them?
That is if it the details.
No, but this one he phrases that we are told.
Yes. Who told
I listened to him carefully.
No, I just played that.
Who told him these contents? But you see, how come that he, John Darko, his own colleague, Afenyo Frank Anodompre, brought a petition for the removal of Loretta Lamptey. President Muhammad didn't say it was an MPP MP against my appointee. He received the petition, actioned it, he found merit, and dismissed his own appointee. How come that today, Anodompre and his minority do not have confidence that President Muhammad would do same thing he did to Loretta, affording her the opportunity to defend herself? Where is the fear? Where is the panic? You see, the stand of the minority relative to this broader national issue actually betrays a certain thing. It is extremely revealing. What is it? In all these constitutional arrangements, there's only one person under Article 146 to perform that role of receiving a petition. It is not Professor Ranford Jampo. It is not my learned friend here or this big man, not even me. Only President. The President. Who is the President of Ghana? Possibly the petitioner should have addressed it to the MPP minority before and given it to Afenyo Markin so that Afenyo Markin can consult the Council of State in this process. Malene Senior, you were called to the bar before me, and I've always been inspired by your legal work. What exactly is the complaint against John Mahama? My senior John Darko, what exactly is the complaint against President Mahama? Now, when you assume the position of now deciding that a petition is frivolous, are you not usurping the powers of President Mahama and the Council of State? Lawyer Darko, it is rather your conduct that is unconstitutional. It is rather your conduct that is unbecoming of a lawyer. President Mahama so far has only conducted himself within the confines of the law. Akufo did it. The three commissioners of the Electoral Commission were all removed through that process. President Mahama has not invented a new rule. He's just basically holding fidelity to the 1992 Constitution. I think at this point, the minority must stay away and allow President Mahama to perform his constitutional responsibility. If there's any merit, and I've always said, thankfully, the Council of State has a retired Chief Justice on that committee. Her guidance, and in fact, thankfully, she even is in a very interesting situation. You know why?
Relationship.
No, Charlotte Osei's prima facie determination was made by who?
By her.
By her. So if there's anybody that has that experience, she'll bring that experience to bear. What did she see? In fact, if she's somebody who could make, yes, if she could make a prima facie determination for the removal of Charlotte Osei on her own, or even that one on her own, because remember that the process is different. If it comes to the Chief Justice, it's a different rule. But for other Superior Court judges, it's the Chief Justice that makes that determination. And she found it that in the case of Madame Charlotte Osei, the evidence of breaches of the Procurement Act was enough to warrant the establishment of the 5-member committee chaired by His Lordship Justice Benny. Has President Mahama done otherwise? No. So away from this, complete red herring. But it is actually an emotional conversation now. Because you see, CSOs, you must stand for the judiciary.
I'm here, I will speak.
Has President Mahama, as we speak, President Mahama, has he appointed any judge?
No.
Has he appointed any judge?
No.
So where from the interference? Has President Mahama asked that a particular judge should sit on a case involving him or his government? No. If there was any evidence of judicial interference, kindly look at the African peer review report in 2004. No, 2005, even though it reflected 2004. When the Chikata trial, the fast-track composition, where in the midst, President Akufo appointed Justice Afre to the Supreme Court and got onto the panel that reversed the original fast-track decision. The African Peer Review Mechanism report indicted the president as directly interfering in the judicial process. President John Dramani Mahama does not have that reckless record. So where is the conversation going?
Okay.
President Mahama, on the 7th day of January 2025, in taking his oath, said, I shall respect the 1992 Constitution. What Afenyo Makin and his micro minority are doing is to say, President Mahama, disobey the Constitution, which will now be a ground for his removal. Because remember that if the president disobeys the constitutional order, that's grounds for his removal. Indeed. At this point, with all the counsel available to President Mahama, he is fortified not to obey that recklessness, but to stick to what the Constitution says.
Right.
Let's see what the coming days will reflect.
Indeed, but lawyer Christian Mamhesi as well on this, because where is the concern really so far in the process as it's unfolding under 146, Article 146? Where exactly does the position by, for instance, the immediate past Attorney General have merit that to the extent that there is an application for an injunction, the process should be put on hold until the determination of such a case before the process resumes, to hear even the petitions against the Chief Justice and have that consultation with the Council of State? Where does that argument have merit?
Okay, all right. It refers to, there's this case that came before Akabuafo. J. Asiden was now at the Court of Appeal, where the case is ex parte Mahama Bugri. And in that, he had to deal with an injunction application. And in his ruling, he indicated that, amongst other things, where there are pending procedures of court, such that a ruling or judgment had not been given, and in such an injunctive application, especially when it has been served on the party has apprised himself to such proceedings as ongoing, then it requires on that particular person to hold on by actions that the person, hitherto that particular application being served on him or her, would have taken. Now, it meant that it is not only, and this relates to where injunction has been served and one is seeking to take steps and crossing into the line of usurping or interfering with the administration of justice. And it fringes into, like I fringes into, it further fringes into issues of contempt.
Okay.
So it has to do with an injunction application served on the party where the application is yet to be taken, but the party carried actions so to overreach the court in respect of determining that particular application. So that was how this particular decision was borne out.
I see.
Yeah.
But well, the concern is that if really, and no, but Prof, I'll come to you to the extent. Let me stay with Lawyer Christian Mamhes in a bit. So is that to say that with this injunction by that's Vincent Assefa and another at the Supreme Court, the expectation was that the president should halt the consultation with the Council of State on these petitions against the Chief Justice and asking for her removal?
It will, you see, legal jurisprudence helps the law so that in this situation where the actions of the president conjunctively with the Council of State, one is aggrieved by it, whether it is meritorious or not, out of which an application has been served. The jurisprudence behind it is that just as I explained in respect to this decision as reached by Akabuafo J, it means that, you see, and you will transpose that to Section 10 of the Criminal Offences Act at 29. We also look at Article 1912 of the 1992 Constitution. That deals with fair hearing and also issues of interfering with justice administration or matters before the court. Now, the whole reason is that, and just as I said, when the application is served on you, you have to allow the court to determine it. At the end of the day, you seeking to carry out with a particular step has to be run in juxtaposition to what the court would say. And in determination of what the court would say, if it should go contrary to whatever step that you are taking, it will not run in sync with it. Now, if you take further steps, it would also be deemed as, just as I said, usurping the powers of the court. And to allow for the balance of rights of whatever the aggrieved situation or issues are, natural justice or, fair trial requires that allow the court to determine the application.
But I think, let's be fair, Counsel. You see, relief one of Asifua's suit. And always remember that an injunction doesn't stand alone.
Yes.
There's a primary document, which is the writ.
Yes.
Then the injunction is predicated on it.
Yeah.
Relief one of Asifua's destiny is that, to the extent that President Mahama did not notify Madam, her ladyship, the Chief Justice, prior to the consultation with the council, it was unconstitutional. Relief one.
That's true.
Now the president had gone ahead, not only notified her, submitted the petition to her for her comment.
That's
so
true.
the primary relief, hold on, Leonard.
No.
The primary relief had effectively become what?
Moot. Nobody is arguing
So the issue of holding the balance has been taken care of.
Yes.
And you see, if you read the decision you premise, my Lord Justice Akabuafo's decision,
Yes.
you notice that he also gave a caveat that where the person is performing a constitutional duty, the court should be slow in clogging that constitutional duty with injunctions.
Okay.
In the same decision. So the judge then provides two scenarios. Oh, land, typical land issue. Oh, you are building on my land, there is litigation. Court can say, okay, hold on. Because you are building, stop. Let's get it done. But he said, look, once the person, and flowing from the decision in ex parte Ghana lotteries, he was fortified by that decision to say that once the person is performing a statutory or constitutional duty, the court should be slow in clogging that performance with injunctive orders, which finds expression in the decision that His Lordship Justice Akabuafo made. So he provided two scenarios. In this specific case, who else can receive a petition for the removal of a Chief Justice? The President. Who else will consult the Council of State? The President. So at this point, it is a duty that can only be performed by only him, not even the Vice President, not even the Speaker. So, Leonard, let's situate the conversation properly so that it doesn't look like the claim by Mr. Godfrey Ibuadami. And for him, like I said, I didn't want to because I did e-levy with him. Immediately the president assented. They started the collection, even though we were in court.
Okay, so that's why...
I was in court that day with him, and he justified it.
So you say that the...
Incidentally, hold on. Incidentally, that panel, that e-levy panel, the leadership, the Chief Justice on it.
I see.
Yes.
So based on the argument that you're making, to the extent that even there's precedence to what is happening now, the former President Akufo was wrong to have assented to the e-levy, even though there was an injunction hearing ongoing or in place?
Yes, I mean, just as he said, you see, in the decision, the learned judge was even slow and cautious in making that particular decision. I mean, in response to issues of constitutional duties. You see, what is I love legal theory and jurisprudence a lot because what is the philosophy of the law? At the end of the day, in the situation we positing it in rule of law and looking at achieving justice at the end of the end goal is to achieve justice. Now there is an ongoing process under Article 146, and with that process, Article 146 has been invoked. However meritorious or unmeritorious that particular application is, we all agree that that application has been rendered moot because the president has afforded her leadership the opportunity to respond. Now, for jurisprudence sake, what would it be for the president to allow that particular application to be heard in order to ensure that, yes, rule of law has been upheld, and for whatever it is, even though in the Akabuafo decision, there was a caution by the courts to hasten slowly in dealing with constitutional matters, the decision did not serve as a bar, but it only indicated that when it comes to that, let's hasten slowly as to what the situation would be, or for further decisions to come, whether from the High Court or especially from the Supreme Court, to authoritatively declare on how matters involving constitutional matters should be dealt with. The situation would keep evolving. Now, in the milieu we find ourselves, one would say, or legal scholars would be split into two schools of thought of should we allow, or should we say that where constitutional matters are involved in an injunction application is served, should the constitutional duties carry on, or there's a caution by a judge, by a learned judge, who indicated that yes, the constitutional duty is important because it is in respect of state duty. So let's hasten slowly. How do we deal with it? So these are matters of constitutional jurisprudence, and a clear decision ought to be taken to deal with such matters.
Because then anybody else will just go to court. And you see, for example,
I want to understand so that I can contribute.
So it's okay. Because you've made your point, I want to understand
because
it's okay.
Let me receive some. Eduji's exposition on this matter brings some clarity. But when I listen to him, I get
allow me to just stay on the course on this matter. So, what exactly has President Muhammad done wrong exactly in this matter?
Look, so in simple terms. In simple terms, an application for an injunction, simpliciter, when served on you, you have to restrain yourself. That is the legal thinking behind it. You have to restrain yourself from taking further steps until the matter is determined.
Despite what the judge,
I'm building a point. I said an application for injunction simpliciter, when it is served on you, you have to restrain yourself, whether or not the matter is heard or not. So, pending the matter to be heard, you will restrain yourself. If the applicant can prove to the court that indeed there is proof of service of that particular application on you, you have been apprised with all that, and yet you took further steps with it, that particular person can bring a contempt application under the rules against you.
Catch the president.
Now, I mean, in the US, it is not far-fetched. I mean, where Donald Trump engaged in the deportation, it also deals with such injunctive applications. I'm giving you the broader legal thinking behind it, or the legal theory and jurisprudence behind it. And it is one that is espoused in the Commonwealth, you know. And in such situation, the federal judge, Boagas, indicated that he could hold Trump's administration for contempt, for possible contempt, because they have further taken steps in dealing with the deportation of over 200 immigrants. Now, that said and put behind, the point is that, which I was building up, is that having said that applications or matters pending served on you, further steps ought to be restrained. In the same way, or by the same decision, the judge further went on to caution that when it comes to constitutional matters or constitutional duties, we have to hasten slowly.